All right, here's a fascinating legal puzzle for you, coming straight from India's Supreme Court. Imagine this. Can you ask for a do-over after the game is already finished? Well, that's pretty much the question the court had to tackle in this really interesting case involving a disputed signature and some, let's say, very late evidence. Let's dive in and break it down. So this is really the heart of the matter. Picture this. A trial is totally done, finished. The judge has delivered the verdict. And then one side suddenly says, hey, wait a minute, I want to bring in a new expert. Is that even allowed? Or is it just game over? That's the puzzle we're going to unravel.
Okay, so let's set the scene. We've got a lawsuit where the trial had already wrapped up, completely finished. But then, all of a sudden, the defendant decides to challenge a signature on a really important document. They say, we want a handwriting expert to take a look at this. But there was one pretty big problem. The final whistle had already blown on this case.
Now, to really get what's going on here, we have to look at the official rulebook. In India, that's the Indian Evidence Act of 1872. Think of it as the playbook that governs everything about how evidence is presented and used in court. And believe me, it is absolutely central to solving this puzzle.
So the defendant's move here was a very specific legal play. They pointed to Section 45 of that act, a rule that lets you bring in expert opinions, to ask for this handwriting analysis. But the most crucial part of this whole thing wasn't what they wanted, it was when they wanted it. And okay, this is where the story gets really, really interesting. Because when the defendant made this super late request, the legal system itself just couldn't seem to make up its mind. You had two different courts giving two completely opposite answers. A total legal contradiction.
Let's follow the journey of this case because it's a bit of a roller coaster. First up, you have the trial court, the court that heard the case in the first place. They said, nope, sorry, way too late, request denied. But then the defendant appealed to the High Court, and the High Court looked at the exact same facts and said, yeah, go ahead, request approved. So now you've got two courts saying the complete opposite. Where do you go from there? Well, there's only one place left, the Supreme Court, for the final binding decision.
The trial court's logic was pretty straightforward, right? The trial's over. The window for submitting evidence is closed. Simple. But the High Court's reversal? Whoa. That blew open a massive legal question. Can you just hit the rewind button on a case whenever you feel like it? This was the mess the Supreme Court had to sort out.
And so we get to the main event, the climax of our whole story. All eyes are now on the Supreme Court of India. It was up to them to sift through the law, the facts, these conflicting decisions, and finally solve this puzzle once and for all.
And their answer? Well, it was incredibly clear and direct. In a judgment from November 4th, 2023, the court stated, and I'm quoting here, in our considered view, the High Court has committed an error in reversing the order passed by the trial court. Basically, they said the first court, the trial court, got it right all along.
So to put it simply, the Supreme Court slammed the brakes on the High Court's decision. It was overturned. That permission to bring in a new expert after the trial? Gone. The final word was in, and that word was, it's too late.
But, the verdict itself is only half the story. The really important part is the why. The reasoning behind the decision. And the court's logic here, it shines a light on a really fundamental principle of how our entire justice system is supposed to function. And it all boils down to one thing: timing.
So the Supreme Court laid out its logic in 3 key points. First, the timing was just flat out wrong. You can't just finish a trial and then ask to bring in new evidence. Second, they talked about the burden of proof. It was on the plaintiff to prove their case during the trial, not on the defendant to try and disprove it after everything was over. And third, that rule they used, Section 45, the court pointed out it's for comparing a signature to a document that was already part of the trial evidence, not for starting brand new comparisons later.
Here's a good way to think about it. It's like a championship game is over, the trophy has been handed out, the confetti has been swept up, and then a week later the losing team says, hey, could we get a video replay on that call in the second quarter? It just doesn't fly, right? There has to be a point where the game is officially, finally over. And this is where we get to the really big picture. Because this ruling, it's not just about one signature and one lawsuit. No way. It reinforces a principle that is an absolute bedrock of the entire legal process. So why does having a clear finish line matter so much?
Well, think about it. These procedural rules are what hold the whole system together. First, they ensure fairness. It means each side gets a clear start and a clear finish. No one can just drag things out forever. Second, they promote efficiency. Can you imagine if cases could just be reopened endlessly? Nothing would ever get resolved, and finally, they create order and predictability, so that when a judgment is made, it's final, and everyone can actually move on.
So the big takeaway from this case, Hussain Bin Awaz versus Mittapally Venkataramulu, is a really powerful one. It just hammers home a core principle that's true in the courtroom and, well, in life, right? There's a right time for things, and when it comes to the law, you have got to present your evidence before that final whistle blows.
And that kind of leaves us with one final thought to chew on. We almost always focus on the outcome of a case, right? Who won, who lost, who was right. But this ruling is a powerful reminder that for justice to truly be fair, maybe the rules of the game are just as important as the final score. Something to think about.